Welcome back to Lost Touch Channel. My name is Anton Vieltsin. I'm a criminal defense attorney in the Southern District of California here in San Diego. Did you realize that the courts sometimes can act as though they're the 13th juror? Well, think about it. If somebody went to trial and lost, that individual can later appeal, and the appellate court can reverse that conviction, essentially being the 13th juror and saying whatever the 12 jurors at trial did was wrong, and so they're reversing the conviction. And when they do so, they can do it based on the weight of the evidence or based on insufficiency of evidence. Why does that matter? Well, because sometimes the state or the federal government, depending who's prosecuting this individual, would be barred from retrying or bringing the second case against the individual, because they would be barred due to the Double Jeopardy Clause. And then sometimes they wouldn't. This is the case just about that. In this video, we're discussing Tibbs versus Florida, a Supreme Court case dealing with double jeopardy. As always, I'm going to first discuss the facts with you, then we're going to talk about what the lower court did in this case, and then of course we're going to talk about the law that came out of the Supreme Court's opinion. Here's what happened. Milroy and Nadeau were hitchhiking near Fort Myers. A man in a green pickup truck picked them up. Then they both drove, and at some point the driver asked Milroy if they would drive off into the fields and siphon some gas out of this farming equipment. And they agreed. So when they drove off into these field, the driver told Milroy that he wished to have sex with Nadeau. He then forced Nadeau to engage in sodomy at gunpoint. At some point, he also told Milroy to walk away. As Milroy was walking away, he shot him and killed him. Then Nadeau and the driver got back into the pickup truck and drove off. At some point, the driver told Nadeau to get out of the pickup truck and start walking in front of it. We're not sure exactly what was the purpose behind it, but Nadeau thought that this was a perfect opportunity to escape. So instead of walking in front of the truck, she ran back away from it and got help. She then identified Mr. Tibbs to the police in a lineup, saying he was the man who raped her and he was the man who murdered Milroy. At trial, the defense introduced the theory that Nadeau's former boyfriend was actually the person who killed Milroy, and that Nadeau was lying to protect him. They also brought out evidence that Nadeau used just about all the types of drugs, and that she smoked marijuana right before the crime occurred. And that she also could not even recall the time of day during which crime occurred, whether it was day or night. Next, we have Mr. Tibbs, who testified at trial. And here's what came out of that testimony. He was college educated, published stories and poems. He claimed that he was in Daytona Beach on the day that the crime occurred. He did not own a green truck. He did not drive any vehicles in Florida. And then he had two witnesses. Two Salvation Army officers produced a card signed by Tibbs indicating that he slept at Daytona Lodge during the crime. Now, despite the defense's efforts, the jury convicts Tibbs of murder and rape of Nadeau. Well, of course, murder of Milroy and rape of Nadeau. Mr. Tibbs appeals, and the Court of Appeals reverses the conviction based on the 5 items they list. The state did not introduce evidence placing Tibbs at Fort Myers during the commission of the crime. Police never found the truck. Police never found the keys or guns in Tibbs' possession. Tibbs cooperated with the police when he was arrested, and the state introduced no evidence casting doubt on Tibbs' veracity. So they reverse the conviction, but they reverse it based on the weight of the evidence. They're not saying that there's insufficient evidence to convict Mr. Tibbs, but they're saying that when we look at the evidence, the weight of it, we're just not sure. And so based on the weight of the evidence and the presumption of innocence, as the 13th juror, the Court of Appeals reverses the conviction and says, no, the jury was wrong to convict Tibbs. So now let's take a look at the law that came out of the Supreme Court case. Of course, it didn't fit on this board, so give me a moment. I'm going to raise this board and then we're going to go into the law.
Took Beethoven 4 years to write that symphony. Some things can't be rushed. Good music and good wine. Paul Masson's Emerald Dry. A delicious white wine. Paul Masson wines taste so good because they're made with such care. What Paul Masson himself said nearly a century ago is still true today. We will sell no wine before it's time.
We're back discussing Tibbs versus Florida, a Supreme Court case dealing with double jeopardy. And if you recall, the jury found Mr. Tibbs guilty of murder and rape, and then he appealed his conviction, and the appellate court reversed it based on the weight of the evidence. Now the Supreme Court reviews that decision, and here's what they say. First, they make a distinction between insufficient evidence and the weight of the evidence. When we're saying insufficient evidence, it means that viewing the evidence in light most favorable to the prosecution, no reasonable fact finder could find the defendant guilty beyond a reasonable doubt. Now, the weight of the evidence draws the appellate court into question of credibility, determination by the trier of fact that a greater amount of supports one side of the issue or cause than the other. Just like the name suggests, the appellate court weighs the evidence. And in the first instance, the appellate court says there's insufficient evidence. Those are two different things. Now, double jeopardy attaches special weight to the judgments of acquittal. What does that mean? Well, just from the name double jeopardy, and if you ever heard it on the news, or maybe you've read other cases, verdicts of not guilty by either jury or the judge, sometimes people waive their rights to a jury trial and they go to trial solely with the judge. The verdict of not guilty by jury or judge absolutely shields the defendant from retrial. Meaning, if the jury finds an individual not guilty, there's an acquittal, the government or the state cannot retry the case again. They don't get the second bite of the apple. Reversal on insufficient evidence is the same as not guilty. Well, of course, does not make sense. Insufficient evidence means that no rational fact finder could find the defendant guilty beyond a reasonable doubt. That is the same standard as not guilty itself. Now, when we're talking about the weight of the evidence, that's different. The appellate court, as the 13th juror, disagrees with the jury's resolution. Difference of opinion no more signifies an acquittal than does the disagreement between jurors. Again, weight of the evidence. We're just weighing the evidence. It doesn't mean that the appellate court says there's insufficient evidence, just that there's disagreement between the jurors and the appellate court. A deadlocked jury, we all know, does not bar retrial. Now let's focus on this case. The appellate court focused on 5 factors. Remember the 5 factors that I listed on the board before I erased it and put this law here? There were the 5 factors about the truck, about Mr. Tibbs not being in the city while the crime occurred, and so on. Those 5 factors stem from the justice's determination that Tibbs' testimony was more credible than Nadu's. Again, weight of the evidence. We have the testimony by Tibbs and the arguments made by the defense versus the prosecution arguments that Mr. Tibbs is guilty. This is a hallmark of review based on evidentiary weight, not insufficiency of evidence. Again, the appellate court weighed the evidence and said that based on the weight, we can't determine whether this individual is truly guilty of the crime. And because there is a presumption of innocence, he is not guilty, and we're reversing that decision of the trier of fact, the jury. Double jeopardy does not bar retrial. Why? Well, because again, we said that when it's weight of the evidence, it is different than insufficiency of evidence. And based on that weight, we know that deadlocked jury, when there's disagreement between jurors, and now the appellate court as a 13th juror, that does not bar retrial. So double jeopardy doesn't help Mr. Tibbs in terms of any future trials. But for now, he's acquitted and his conviction is reversed. Hope you enjoyed this video and you understand a little bit more about double jeopardy. If you like this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. Thanks for watching.